On April 4th, on the Majority Report podcast, you can hear our interview, which I think we also have on YouTube, with Bruce Affron. He is an attorney representing 7 plaintiffs, including Chris Hedges, Dan Ellsberg, Noam Chomsky, Brigida Johnsdottir, also a couple others I should mention, Kai Wagala, Jennifer Bolin, Alexa O'Brien. And they had head into a federal district court in New York, the Southern District of New York. The judge was Catherine Forrest. Bruce Affron at the time told us that they were attempting to enjoin the government from implementing parts of the National Defense Authorization Act, specifically the Homeland Battlefield Act, because it would have a chilling effect upon journalists and writers, because they could be guilty of aiding and abetting people who were associated with terrorists. In other words, they could call organizations unknowingly or knowingly who were involved with terrorists to do their journalism, and it would create a chilling effect upon them. The first issue that these plaintiffs were going to have to deal with, as Bruce Affron in that interview with us back in April 4th, spoke about, was whether or not the plaintiffs had standing, because they had not yet been detained. The second issue was, even if they had standing, the lack of imminent enforcement against them renders injunctive release unnecessary. In other words, they're not about to be indefinitely detained, so there's no reason for an enjoyment. And 3, that the NDAA creates no new detention powers beyond those that already exist because of the authorization for military force that was passed after 9/11. Well, the court found that, A, they did have standing because they already are suffering substantial injury from what the court found was a reasonable fear that they could be subject to this provision. Section specifically 102(1). The court writes, plaintiffs assert that 102(1) already has impacted their associational and expressive activities and will continue to impact them, and that 102(1) is vague to such an extent that it provokes fear that certain of their associational and expressive activities could subject them to indefinite or prolonged military detention. And the courts found that, yeah, they actually do have a justifiable fear of this. And at one point during the hearing, the court had asked if the DOJ, the Department of Justice, could state clearly that these people would not be subjected to this Section 102(1) based upon the actions that they normally involve themselves with. And the Department of Justice said, we can't answer that question. So the court found that the plaintiffs have stated more than a plausible claim that the statute inappropriately encroaches upon their rights under the First Amendment. The court also found that the plaintiffs are likely to succeed on their claim that the NDAA violates their Fifth Amendment of due process rights, because there's really no way to know, based upon the way the statute is written, where the line is that they cross that could actually cause them to run afoul of the law. Nobody knows, quite frankly, what direct or substantial or the word support means. It's not defined. So you could actually be guilty of doing this without even being aware that's what you were doing. The court also cited 3 reasons why the NDAA expands the government detention power over the 2001 authorization for military force. So this is a huge, huge win that I think a few people actually thought would happen. So go back, listen to that April 4th interview. We have it on YouTube if you want. We'll put a link to it on majority.fm. But this is a big win. Undoubtedly, there'll be an appeal to this, but this is a rare case where a judge was brave enough to stand up to the Department of Justice in this. And you'll recall, Occupy Wall Street people were arrested in Grand Central Station protesting this. This is a big win.